Good evening, everyone. Welcome to tonight's webinar. This is Dr. Lorne Lavine. As of this morning, we had around 350 people that were registered for the webinar, so I'm very pleased with the turnout. I see a number of people are logging in right now. I'm only going to speak for a couple of minutes initially. I want to make sure that we leave as much time for Rohit to speak as well. We also want to make sure that we have plenty of time to have people get their questions answered tonight. All of you, if you have not been on a webinar before, you should see a little GoToWebinar control panel where you can just go ahead and ask your questions, type them in as you think about them. Typically, we don't actually get to those questions until the end of the webinar, but for tonight, if I see a question coming in while either one of us is talking that I think is relevant, I'll go ahead and ask it. The goal for tonight's webinar is to be a little bit different than some of the webinars I've done in the past, where it's going to be a little more conversational. Rohit has a lot of experience with this. I certainly am getting more experience with HIPAA and high-tech and all the regulations. So I think it would be beneficial to have a little back and forth between us, but certainly we encourage your participation as well. Within the next couple of days, you should see a number of things. When you log out tonight, there's going to be a short survey. If you'd like either myself or Rohit to follow up with you, please indicate that as well. We are downloading this webinar as we do, we're recording the webinar as we do for all of our webinars. So usually by tomorrow you should get an email sent to you with a link that you can download the entire webinar. So don't worry if you get distracted or you have to log out earlier. As I said, we are recording it. For those of you who are interested in AGD PACE continuing education credits, we will send out the information on how you can obtain that as well. So many of you have been on previous webinars. You know this is Lorne Lavine. Many people know me as the digital dentist. What I've been trying to do over the last number of years, it's been almost 5 years now, is to present webinars on topics that I just think are interesting, that dentists that I speak with want to know about. Sometimes they fall into my area of expertise, which is technology. Certainly that's to be true for tonight's webinar. Sometimes they're clinical in nature. Really the goal here, though, is just to give you some content that's hopefully stimulating and interesting and sometimes a little controversial. I'm sure there'll be some things tonight that Rohit and I talk about that other speakers on this topic may not 100% agree with, and that's okay. But really, at the end of the day, as long as it was beneficial and you got something out of it, then it was worthwhile. So, as I said, even though I feel like I would not call myself a HIPAA expert, I'm getting there. I've done a lot of reading. The HIPAA and high-tech regulations have been around for close to 10 years now, so I'm getting a lot more familiar with them. But the good news is that we do have someone here tonight who I really do consider to be a HIPAA and high-tech expert, and that's Rohit Joshi. I've known Rohit for a number of years. He's held senior executive positions with life science and technology companies all across North America, really focusing on using technology for effective communications. He's got a bachelor's degree in biology. He's got a master's in medical science. He's also a lawyer. He's one of the few lawyers I actually like. So it really gives me great pleasure to introduce Rohit. I'm going to change the screen over to him and get him on the mic, and we're looking forward to what he's got to say. And as I said, we're going to be both speaking this evening. So take it away.
Well, thanks very much, Dr. Lavine. I appreciate the opportunity to sort of address everybody. Let me just share my screen with you now. Before I get started, I just wanted to let everyone know that this is the third, I suppose, Dr. Lavine, in the series of HIPAA webinars that we've done. The first one I think that we did was called 10 Burning Questions about HIPAA Compliance. The second one was your first 3 steps towards HIPAA compliance. And in addition to those two, we've actually done another one recently just about cloud and the cloud technologies. And we did that webinar with Curve Dental and Demandforce, a couple of companies that many of the people tonight on the call might be familiar with. In any case, there's always, at the end of these webinars that we've done, there's a pretty good summary opportunity, not only to watch the webinar, but to get a pretty complete list of the questions that were asked during the webinar, plus even some type, I think in the last webinar that we did, there was a checklist that people were interested in about different type of software and compliance checklists. So if people are interested, if anyone here on the webinar tonight is interested, just enter the word series in the comment box as Dr. Lavine described, and we'll make sure we send out links to all of that information. Again, I think a lot of our listeners have found that pretty valuable, and we'd love to share that information. But let's get on to the order of the day. I think today's webinar is a very interesting topic. It's certainly one that, as we are in many practices, and Dr. Lavine, I know that you're in many practices as well, we see a lot of things that are sort of base level compliance issues, base level HIPAA issues. And for that, we wanted to create a very simple webinar on places to focus, I would say, for the practice, what the practice can do to sort of get out of the danger zone with respect to the HIPAA regulations. And I mean, Dr. Lavine, you and I have talked about this, quite a bit, in the sense that it's difficult to know how far to go. It's difficult to know when you're HIPAA compliant, but it's not that hard to figure out where to start from. And that's where we really wanted to focus this webinar, because we recognize that there's lots of things that people do every day that simply are not compliant. So the first one is sending sensitive patient information through email, whether there is a communication with the lab or the specialist or someone else about that patient. We see that happening every day. The second item is using Dropbox or systems like it to share and store patient data, and we'll talk about all of these, of course, in some detail. The third item, not backing up patient data regularly, and for that, Dr. Lavine, I'll probably lean on your expertise, because I know that you've been in a number of practices where you've been able to help find a solution for this. Not encrypting patient data, number 4, and number 5, not restricting access to patient information. So let's start walking through those now. And I'm going to take, before I jump into the first one, which was sending sensitive patient information, I think it's pretty relevant to talk a little bit about the basis of HIPAA laws and privacy laws. And because I think it's a little bit easy to say, well, the regulators aren't going to come after us. That's absolutely could be the case. I think that what we wanted to do, though, was talk a little bit of just about the root of HIPAA laws and privacy laws, and they're based in part in the doctor-patient confidentiality in dentistry. The idea that the patient will share information with their dentist because they trust that the dentist will keep that information private. And there's lots and lots of examples about how having that trust allows you to deliver the best care. You need to know what prescriptions that patient is on. And they're not necessarily going to tell you if they believe that someone else might find out about that, including some of their family members. So that trust engenders a very important bond between that dentist and that patient. So the duty of confidentiality in that realm really requires 2 elements. And they sound sort of similar, so I'm just going to take a couple of seconds to talk about them. The first is that you're prohibited from disclosing private health information or protected health information. And that means that you just simply cannot talk about these things. You can't make it a part of your day to discuss your patients with people who shouldn't hear it. The second element of the duty of confidentiality is actually to positively enforce safeguards or positively take measures to ensure only authorized access occurs. So there's kind of a passive system where, listen, I just can't talk to, as a doctor, I wouldn't be able to talk to anyone about my patients. The second is there's actually a positive duty for people to take measures within their practice to ensure only authorized access occurs. Now, the last bullet here is just that there's issues around when that breach occurs, when the breach in confidentiality occurs, how do people get notified? We're actually not going to talk about that in this webinar because that's almost a topic to itself. So we're gonna kind of leave this, but certainly if you have questions about doctor-patient confidentiality, you know, I'd be happy to address them in the webinar. Again, please just enter them in the into the comment box, and we'll get them. So let's, you know, as they say, start at the beginning. The first element that we wanted to talk about, that many of our practices that we visit every day are doing, is they send sensitive patient information through email. The fact of the matter is that using email to share protected health information is against the law, and protected health information is information about the patient, basically. So, you know, this actually, when we talk about it to many practices, it comes as a bit of a surprise. Because email feels private, you know, I'm the only one who can receive it, it feels almost as though it should be private, and that that would be quite okay to send patient information through that network. Well, in fact, you know, the mechanics of the email is not that way. In fact, email was never designed to be private. What happens with email is it goes from my computer, even if my computer is secure, and sends it through many servers on the internet before it finally reaches its destination. And at any point, those middleman servers, those servers that are not my system and not my recipient system, that message can be intercepted. So even though I might feel like my computer is quite secure, in fact, as soon as it leaves my system, it isn't. And as I mentioned before, there is a positive duty to take precautions to safeguard this patient data.
Hey, Rohit.
Yes, sir.
We did have a question here about HIPAA, because I know that we're talking, most of the callers on tonight are certainly from the States, but I know we do have some Canadian people as well. And yes. Would the laws related to email apply to people in Canada as well as the U.S.?
Absolutely. You know, I should be mentioning HIPAA quite a bit more. The laws are analogous. So when I say HIPAA, people who are in the Canadian jurisdiction, or if there's even people overseas listening to this, there's a great deal of crossover with the EU, with Japan, and Australia, where we have users. And so I've had the opportunity to go through their laws and recognize that really the laws are similar enough that often I say HIPAA because that's where our largest user base is in the U.S., but it certainly applies.
We also have a question that just came in about the caller is a specialist and they regularly send patient info such as radiographs to the general dentist. Are they in violation of HIPAA? My understanding is if there's any identifying information in that email that they would not be in HIPAA in compliance. Is that your understanding as well?
Yeah, that's absolutely correct. The thing about sending a radiograph, for example, that doesn't have any patient information is that no one who's receiving it will really actually understand who it's about. And so typically when we see the information, the email not only has the image, but it'll also have the patient's name. And in some radiographs, some systems actually imprint the patient's information directly on the radiograph, and so that's in clear violation because the information is directly connected.
Now, the other issue, I assume that if there's an encrypted email, which hopefully you'll talk about at some point in the webinar, that would certainly be in compliance with HIPAA and PIPEDA, correct?
Yeah, exactly. Yeah, the PIPEDA laws and the HIPAA laws are quite clear that as long as the information is encrypted, then it can be sent. And yes, I certainly will be talking about one of our products actually called Secure Mail, which was built directly for this.
Great. Okay, thanks.
Before I leave email, though, I want to talk about some of the confusion about email. And so, if you go to the American Medical Association site and look up the frequently asked questions, it says right on there: is it okay for a physician to discuss patient treatment with other physicians using email? And the answer from the American Medical Association says yes, it is. But the interesting element of that, or the sort of the loophole in there is so long as the physician uses reasonable and appropriate safeguards to protect the communication. And so we did a bunch of research to try to understand how could the American Medical Association come out and say email is okay. Well, what it comes down to is the definition of reasonable and appropriate safeguards. And so if you look at the reasonable and appropriate safeguards, in this case, it talks about, verifying email addresses, de-identifying the information, transmitting the minimum necessary, encrypting, de-encrypting, and so on. And so I'm just seeing that this may not be showing up on your screens. Okay, now it's there. So what you'll see is that you can only use email if the patient actually has consented to the use of email, verifying the email addresses of the recipients, you've de-identified the information, which goes back maybe to the question that was asked earlier, Dr. Lavine. You transmit the minimum necessary, and if you encrypt and decrypt the electronic personal health information, which is quite difficult to do, and then you do not email sensitive information or diagnosis. So, it's true that the American Medical Association says you can use email, but you can only use it if you meet all these criteria, which ultimately, from our, view of it, renders email, almost useless.
We have another email question if you have a moment for that.
Oh, yes, absolutely.
So this is kind of good because I know exactly how you're going to answer it, but this was from a caller up in Idaho who wants to know, they contacted their IT guy about this matter the other day, and he stated that the security rule allows covered entities the flexibility to determine when, with whom, and what method of encryption to use. I'm not sure I necessarily agree with that. They leave it up to the discretion of the practice and individual circumstances. He said that it would be cumbersome and time-consuming to encrypt the emails. Now, I don't believe that second part is true at all, because you'll talk about a very easy and not time-consuming method. But is there a lot of flexibility in how practices, what they should be encrypting? Because my understanding is that's not necessarily the case. It really applies to all EPHI.
I would not listen to that IT person. I think that the reality is that there is a little bit of flex in the HIPAA laws that do kind of give a little bit of wiggle room for some technologies. But the fact is that, and again, Dr. Lavine, you and I have spent a lot of time talking about this, the barrier to doing secure email is so low that it isn't reasonable to say that it's difficult to do. And therefore, it's a reasonable measure to take. And I believe that's how the regulators would look at it.
Okay, works for me.
And I know that you and I have had this discussion before, Dr. Lavine. If there's something you want to add to that.
No, not at this time. Now, do you guys have any documentation that I know we talked about that you can send some stuff out to them? But what is actually included in protected health information? What that EPHI, what exactly that means? I mean, my understanding is it's basically a name, social security, date of birth, all that type of stuff. But do you have anything in your documentation that you could send out?
Absolutely, yeah. We would send that out, and we've actually got a checklist around that. What we consider to be, or not what we consider, what is considered to be protected health information. And it gets very specific, because it goes down to patient images as well. And sending a full face of a person, for example, even if there's no name attached, would be in violation of protected health information.
Okay, great, thanks.
So let's talk about some services that we all use. I think the most interesting ones, to kind of make this very concrete here, are using Apple Mail and using Outlook. On the top part of that slide, what you see is Secure Mail, and that's our product we'll be talking about. It's compliant. We can have 500 megabytes of an attachment size and unlimited storage, but we'll leave that for now because we're going to dive into that in a little bit of detail. If you're using Outlook or Apple Mail, it's very unlikely that that is a secure transmission. Even if it's secure, it's unlikely that it has an auditable an audit capability, which is required for HIPAA and PIPEDA. So there's going to be some people that may have some encryption on their Outlook, but you would know if you had it. Depending on the service, you'll have up to 10 to 25 megabytes to transfer, and storage can be limited as well. More likely is that you're using a service like Gmail or Hotmail or AOL, and for Gmail in particular, it's not compliant, and it's quite clearly stated in the Google terms and agreements that Google reads all emails. And it's not someone sitting down and reading them. It's, in fact, a machine going through your emails and being able to serve ads to you while you're reading it. I know that my Google email, when I'm using Google email, will show me various ads for businesses in my area. And that's because Google has the intelligence to reading those emails. All that to say, it's definitely not compliant. And again, there's attachment size restrictions and storage restrictions as well. So I'll leave my discussion now for the email, and we'll pick it up at the end of the discussion when I show you a little bit about our product called Secure Mail. But for now, I'd like to leave email and kind of jump into the second big item, which is using Dropbox. Basically, what we have seen is that people will use Dropbox to share large patient images quite regularly. So in a radiograph, a DICOM image of some sort, people tend to store that onto Dropbox. Dropbox, for one, is quite clear that it is not HIPAA compliant. Neither is SkyDrive, and neither is Google Drive. And Google Drive being the one that's probably clearest about the fact that they're going to look at all of your information in their terms and conditions. So in order to be HIPAA compliant, there's a number of specific safeguards that are required. And those systems there and the other systems that are like them simply don't have the necessary requirements. The first element is called auditability. And this is one of those HIPAA and PIPEDA regulations that require the system to automatically record who actually has looked at a patient image or who actually has had access to that information. And so if the system can't produce a log of everybody who has had access, it's not going to be in compliance. The second item is an automatic log-off. Again, part of that is just to protect someone from walking away from their computer and someone else sitting down and being able to just access all those files. So there's an automatic log-off provision that says after a certain number of minutes that the system needs to log off, a certain number of minutes of inactivity. The third item is just, frankly, it's just basic privacy. If you look at Google Drive, they're scanning the documents that you're writing and storing in there so that they can serve you very specific advertising. There's items about data disposal. So what happens to that data after you're ready to get rid of it? Does SkyDrive get rid of it? Does Dropbox get rid of it? Or does Google Drive get rid of it? And it's most of the time pretty unclear. And the final item is encryption. And I'm going to talk about encryption a little bit, so I'm not going to go into too much details about it now. But it's very important. What encryption is it basically puts all of your information or all of the patient's information through a mathematical formula that makes it unreadable for anybody who doesn't know how to unencrypt it. And so with that in mind, Dropbox, SkyDrive, and Google Drive are kind of based on the fact that they're easy to share, and anybody who has access to that folder should be able to get that information. So, so those systems are not okay. And in a similar slide as we had before, a Dropbox, in fact, says this right on their website. They do not currently have HIPAA certifications. The SkyDrive is not HIPAA compliant. And Google Drive does say that they could be HIPAA compliant, but there's a number of steps that are required in order to meet that. And as I mentioned before, that's part of that long list of things that's required to be HIPAA compliant. So the second I guess, things that many people are doing is using Dropbox or these file sharing systems in order to share patient information, and that's an easy one to solve. Stop doing that. All right. Item number 3, not backing up the patient data regularly. HIPAA laws require that you back up electronic patient data. Now, it's a little bit more complicated than just backing it up. In fact, what's going to be required is that you have an off-site backup, that you have tested that backup to make sure that if, in the event you do lose your systems, that you can restore any of that loss of information. Thirdly, that information is encrypted. And again, I'm going to talk about encrypting in a little bit here. But basically, the purpose of encryption is that the protected health information is unusable, unreadable, and indecipherable to unauthorized individuals. And the final one is that you need to test your systems. So there has to be periodic testing to make sure that in the event you do end up losing your patient information through a hard drive failure or something that happens in your office, that you can get that information back and that you've tested the fact that you can get that information back. Now, this isn't really, to be honest, our area of expertise. Dr. Lavine, if you could weigh in here, that would be much appreciated.
Sure, and we have been recommending obviously data backup and more recently disaster recovery systems for our clients for a number of years. And honestly, Rohit, it had very little to do with HIPAA and high-tech and PIPEDA regulations. It was more from just a safety standpoint, from a security standpoint. Obviously, that's important, but we think it's critical for a dental office with more and more offices putting their information into their computer systems, that having a good backup of that data, being able to verify that backup, and having a system in place that can get you back up and running quickly is critical. Most dental offices could not afford to be down for multiple days. It would just be very devastating. So I agree with everything that you have on the slide here. The system that we've been advocating for our clients is a two-pronged approach. Number one is that we are huge fans of an off-site backup. We do use the cloud. Certainly it is encrypted up there. We use multiple systems to do that. That is critical. The problem with a cloud-based only solution, especially when it comes to disaster recovery, is that if you have to download all the data that a typical office has, which in some cases can be 40, 50, 100 plus gigabytes of data, it's going to take multiple days to do that. So what we advocate is also having a local backup. Now that backup has to be encrypted, obviously. That's what we consider to be called data at rest, so it certainly has to be encrypted. But what we have found to be most effective is to have an actual copy of the server. It's basically called an image that we put onto a device, and that device is normally waterproof, shockproof, fireproof. If an office were to call us up and say, hey, my server just went down, or the power supply blew, or something major happened, we could take that device, plug it into the network, set up a virtual environment, and even though by contract we say 2 hours, it's usually quite a bit faster than that, the office can be back up and running. They have an exact duplicate of their server. They can take digital x-rays. They can function normally, get the server replaced, go ahead and once that's done, take the image and copy it back onto the server. But certainly any backup and disaster recovery system should be off-site. It should be verified on a regular basis. We do that for our clients. It should be tested, and obviously it has to be encrypted. And so I agree with everything on your slide.
Yeah, I would say that much appreciated. Your level of expertise here is extremely important. In Calgary, Canada, where we're based, we had a once-in-a-100-year type flood about a month ago. And I can tell you in downtown Calgary, which is right next to the river, there were servers that were underwater for the better part of 2 weeks, or better part of a week, rather. And and lots of practices.
It wouldn't make much of a difference. If it's underwater, it wouldn't make a difference.
You're exactly,
2 weeks or 2 minutes. It's
you're
gone.
exactly right. And you know, I'm proud to say that our service was unaffected, so people were using our secure mail, but that hardly takes away the pain for all of the practices that were really without their data. So this is extraordinarily important, as you say, from a disaster recovery standpoint, as well as a patient protection standpoint.
Yeah. Now, I do see a question here that someone asked, if the software, which I assume they mean the practice management software, is in the cloud, do you need a local backup? And the answer is no. That is really one of the main selling points of the cloud-based systems. And I'm sure many of you are familiar with systems like Curve and Denticon. There's other ones coming out as well. Shine announced one that they're going to be doing. But the beauty of a cloud-based system is that you don't have to worry about the backup, assuming you're also doing real-time imaging. What we find is that a lot of the cloud-based systems don't do cloud-based imaging. You're taking the images locally and then uploading it to the cloud at night. And in those cases, you would then have to back up and have all the HIPAA regulations and stuff in place. But if it's cloud only, you don't have to back it up. That's really one of their main selling points.
Yeah, agreed. You know, we've talked about encryption quite a bit already. And I can't stress this one enough. But basically, the HIPAA laws do require that all patient data, patient information, is encrypted, and that's any information that's stored or shared by your practice. And you know, the definition of encryption is that it's decoding or scrambling of that information. So it can only be decoded by someone who has the correct decoder key, someone that's authorized to be able to do that. Now, the reason this one's so important, and I think it's probably come up in 3 out of the top 5 things that people should be doing, is because this is where most of the issues are for HIPAA violations, PIPEDA violations in North America. And the reality is, you know, some interesting statistics here are, you know, cell phones get stolen. And people misplace their cell phones or laptops. 12,000 laptops are lost each week in U.S. airports. I mean, it's a surprising number, and I can't tell you the importance of making sure that all of the information on that laptop, on that cell phone, if you've got any sort of patient data on it, that it needs to be encrypted. You know, there's lots of fines that have been issued because someone had their laptop stolen, or someone lost their laptop, or in BC, I think all of that information, they had, you know, 38,000 patient records that were sitting on a USB key that went missing. So, you know, the massive fines for not encrypting data, because once that data has, you know, it doesn't even have to be proven that in fact that data was used for purposes that were, you know, criminal. As soon as you've lost those items that have patient data on them, you are in violation, whether or not it was ever used for criminal purposes or negative purposes. You can see lots of... Oh, of course.
You
Yeah.
want me to do that now?
Please, yeah.
So this is kind of a pet peeve of mine, because those people on the call who have studied some of the HIPAA regulations are probably aware of the fact that there's really 2 types of HIPAA rules and regulations. One that's required, which means you have to do it, and one that's called addressable. And what addressable means is that you basically have to implement it if it is reasonable and appropriate. If you think it's not reasonable and appropriate, then you implement some type of alternative. And if no alternative exists, then you basically say, well, there is no option here, and we're just going to document that fact. And I've seen and talked to a lot of dentists who feel incorrectly, in my mind, that that is a get-out-of-jail-free card, that because it's an addressable concern, they don't have to encrypt the data, they don't have to encrypt emails, anything like that. And I think that's a huge mistake. And the mistake that offices are making is that they really don't understand the definition of reasonable and appropriate. that when there are so many systems out there to encrypt data at rest, whether there are free programs or we do this for our clients. You can buy servers with self-encrypting drives now, but I think almost any HIPAA auditor out there would say it is a very reasonable and appropriate measure for you to be encrypting your data. The other thing is that even if we kind of eliminate some of those rules and regulations, another key issue is the breach notification rule, that if you do lose the data, as Rohit has showed here on these slides, not only are there obviously some violations that have occurred, but the law says, at least for HIPAA, that you have to notify every patient in writing, you have to notify the local media, and you have to have your practice listed on Health and Human Services website. So forget the government rules and regulations. Think about how devastating it would be to your practice if you had to send a letter to every patient saying, oh, really sorry about this, but we lost your social security numbers and credit card information. I mean, that would not go over very well. So, I don't make the mistake of thinking that addressable means get out of jail free, because it really does not.
Well, and just to follow up on that, I suspect that's that type of rule that IT person was sort of looking at when they suggested that there was, that potentially encryption might be an addressable concern. Absolutely. From my standpoint, is not a get-out-of-jail-free card. You need to be encrypting your data. What we've started to see is, the top right hand is there's a hospice in North Idaho that was fined for that very reason. And this was a breach of 500 patients, fewer than 500 patients. And they talked right in the article about encryption being important and required. So
someone asked a question about does password protected count? And my understanding is no, especially the way that most people have their passwords usually on some type of post-it that's right next to their monitor. Password protected is not encryption.
Exactly. No, password protected is very, very different than encryption. If someone can get through that password, which is actually much, much, much easier than you'd expect for anybody with computer knowledge, once they get to your hard drive, they've got access to everything that anybody else would who has authority to be there. So as soon as someone steals that laptop or steals that computer, assume that they have access to all that information, unless it's encrypted. Okay, the final item here. Oh, well, maybe before we go on, Dr. Lavine, do you have a product that you recommend, or part of what we want to do here is give people solutions. So if their information right now, if their data in their office is not encrypted, where should they look?
Well, it depends what data we're talking about. Certainly for the backup, the backups that we do, we encrypt that as part of our service. We have a service called Data Protect, and people are more than welcome to go to our website, which is thedigitaldennis.com, to learn more about that. Typically, most offices have their data on the server, so there are a few things you can do. If you're ordering a new server, we recommend getting what's called self-encrypting drives. That does a lot of the work for you. Makes life significantly easier. We order those through Dell. It's not a problem to get those. Anything from Windows Server 2008 onwards has a built-in program, and that would also include Windows 8, for example, called BitLocker, and that's a free program, and you can run BitLocker. That's ideal to do it before the operating system is on there, but you can do it afterwards without a problem. BitLocker works great. There's a free program called TrueCrypt. It's True, C-R-Y-P-T, which is also a free program. We're exploring other ones as well. Usually when you work with a company like ours, you are paying for the service because it's a lot of time that it usually takes, depending on how much data you have. It could take 5 to 10 hours to encrypt everything, the backups and the thumb drives and the laptops and the server. So you're really not usually paying for the software. But if you're a do-it-yourselfer and want to do a little research, if you're running Server 2008, look up BitLocker and look up TrueCrypt, because both of those are free programs, and once you learn how to work with them, you've got a great solution there. And again, it'd be really hard to argue that it was unreasonable for you to encrypt this data when there's free programs that you can, within a few hours, have everything encrypted.
Agreed. All right. Well, let's jump now into item 5, and that's really about neglecting to restrict access to patient information. So HIPAA laws definitely require to restrict access. When we're in practices, here's the type of things that that we recommend. First of all, from a disposal standpoint, you never want to throw patient files into the trash. Those can be accessed for lots of reasons. Of course, shredding services are great, but there's even services now that will shred and take that information away in a very secure manner from your office, and we would recommend those. Discussing, yes, sir.
We have a question related to that, which is quite interesting.
Yeah.
An office was saying that it's an interesting thing to come across. They have old X-rays. They've taken the films out of their holders. They've destroyed the X-rays with a HIPAA-compliant company. But the X-ray holders themselves have the patient name and the date the X-rays were taken. Can they throw those in the trash, because they're not recyclable?
Yeah, I wouldn't recommend that. And the only, I don't want to stretch the bounds of reality, right? So I think this is where, Dr. Lavine, you and I have agreed that there's some things that simply don't make sense. But let me tell you from a legal perspective or from a regulatory perspective, you don't want patient information that's been associated to your office ending up in the trash. Because if for some reason people pick up that information and they know that that person was associated and there was a radiograph, I can't imagine that being an issue, but it could be. And so maybe practically it doesn't make sense to shred all that data, but I wouldn't recommend that you throw it in the trash.
Yeah, I agree.
That's a good one, though. That's not one I've heard before. So
I thought that was an interesting one as well, because we're not talking the film, but the actual holder. But if it's got a patient name on it and a date, who knows? Why take a risk?
Exactly.
When there's probably a way to dispose it that's not going to put you at risk.
Exactly. Discussing protected health information in public areas, and this one I've come across a number of times where patient treatments are being discussed openly inside the waiting room, for example. With another patient, and this, I'd say that's probably something that happens regularly in practices. And again, the more that patient consultation or patient discussion can occur outside of an area that is already open to the public, the better. Clearly, that means you shouldn't be talking about your patients in an elevator or other public area where you're using the patient's name in any sort of specific treatment. Leaving protected health information unattended in public places or in public areas. And by public here, a lot of times I see stacks and stacks of files sitting on the desks of the receptionist and patient name visible. In one very sad example of a dentist that was actually sanctioned by the regulators, they had put a red sticker that denoted a very specific illness, and that red sticker was on a half a dozen of these files. And even though it was a red sticker and it didn't have on it what that red sticker meant, once that was identified, once you knew the code, you knew what all of those patients had, and the patient name was very quickly connected to that red sticker, and that person was sanctioned for doing that kind of a public sort of notice. Labels and markings on files containing protected health information, and I would go to the red sticky note that happens to denote that on a file. Location and access of fax machines. To be honest, most of the offices now that I'm in tend to have these restricted, but I have walked into some that have the fax machine very accessible, and that thing's whirring all day long with patient name and treatment details from the lab. And that absolutely can't be in a public area. Location and access of computers and monitors. Again, I think that there's more sensitivity to this now than there was 10 years ago. But certainly, if I'm walking in to a practice and I can look at a monitor and that monitor's got someone else's information on it, that should be changed. Those privacy screens are great, or turning it in a way that doesn't allow that. And one very specific example that I have, a practice was inside of a shopping mall, and the monitor happened to face out into the hallway, which had glass. So people walking by that practice would be able to read patient information. And so that was one place that was terribly offside. And then again, the protected health information on mobile devices. If you're exchanging email on your mobile phones about a patient, and your mobile phone isn't using a service like SecureMail, which I'll talk about, your laptops, your tablets, your portable storage like the thumb drives and so on, that's a huge issue and something that everyone should think about sooner than later, just getting that encryption. And as Dr. Lavine has mentioned, this is not onerous. It's just getting some knowledge and taking care of that. Dr. Lavine, I know that we're starting to run into some time issues here, but I feel compelled to ask you here if you wanted to add anything to the slide.
No, not at all. We had a couple of questions, which I think would be a good time to throw these in.
Sure.
Not related to this slide, but two questions that are kind of say the same thing. Asking about the responsibility of the lab to respect these things. And I think that maybe that would be a good lead-in for maybe to spend a minute or two talking about what a business associate is and how they are affected by these laws. Sure.
So first of all, labs are absolutely covered by the HIPAA regulations, and as Dr. Lavine has mentioned, they're covered very specifically in an agreement called the Business Associates Agreement, and your labs will have these available. And basically what it does is it gives you assurances that you have asked the questions if they are HIPAA compliant, and if they are HIPAA compliant, what their obligations are, and that they assume the responsibility for handling that patient data in a secure manner and in a HIPAA compliant way. We work, some of our biggest customers are labs because they feel that they're a much bigger target than a dental practice. And I tend to agree with them because, the larger labs are dealing with thousands of dentists. So if you were a regulator, where would you start, right? You would start with the lab because they affect so many practices. In the past number of months, we've got one lab, for example, that on every shipping label, they used to put the name of the patient. And no other details, but when they were going through their HIPAA diligence, that was one of the things that they got rid of because they didn't want the patient name to show up to the UPS guy who happens to be delivering that package because he doesn't need to know. So, moving on here, there's a number of HIPAA requirements, and I'm not going to go into much detail here. This is a pretty good summary of them, but I want to start talking about some of the solutions to this, and I want to talk a little bit about the service that we've got, which is called SecureMail. And as you'd expect, after talking about this for so many years, is something that we are compliant with from a HIPAA, a PIPEDA, EU, Australia, and Japanese standpoint. We manage our data in a HIPAA compliant way. So the biggest offense that we see, and this goes back to item number 1, is really focusing on how information is sent back and forth. And I've changed all the names here, obviously, but this was an example that was given to me by a surgeon. And this was something that's absolutely not HIPAA compliant. It was sent to a Gmail address, put the subject name as the person's name, and then had very specific images about that patient that were attached, and then ultimately talked about the treatment. I know that this is happening hundreds of thousands of times a day, and it's absolutely not HIPAA compliant. So, in that vein, neither are Outlook, Apple Mail, Gmail, Windows Live, Dropbox, Google Drive, and so on. Because as soon as that information is in those, is transmitted in those ways, you're going to breach the HIPAA confidentiality. Our system, called SecureMail, is, there's a few things. Not only is it HIPAA compliant, but we've actually taken a couple of steps within that email, within our system, to make sure that it's better serving not just compliance but also the dental community. And I'm going to give a short demo about this in just a minute. But I want to point out here, for example, the person who you're sending the email to, you'll see a picture of that person. Now, what that's meant to be is a second visual confirmation that you've actually not mistyped that name, because that person's image is now coming up. So there's a visual confirmation that, in fact, you're sending it to the right person. The second item that we feel is very important is that you want to be able to use the product like you would Dropbox. So our system, you can attach up to 500 megabytes per message. So we've got full cone beam CT scans going through our system every day, because they choose to use our system. Now we've secured where that message is going through the visual confirmation, and we can now put all of those images in the same encrypted online system called Secure Mail. Now we can also, of course, in our subject line use the person's name because it's all 100% secure. The exact same information gets transmitted all the way through. We do worry about all the backups, all the access, all the logging, and it's fully auditable. So without taking much more time here, what I'm going to do is jump into a demo. It'll take me just a second here to set up. So what I'm going to show you here is our basic login screen. Now this is available, as you'd expect, on the internet, if I haven't made that clear before. There's no specific download required. Anybody that logs into our system simply needs a login ID and password. So I'm going to log in now as Dr. Pierre Fauchard and show you Secure Mail. Here's my inbox. My messages is what we call it. And I've got a number of different messages. And of course, this is a demo system. All of the names of the doctors, the labs, the patients, everything's fabricated here. So let's say, for starters, I'd like to look at the information that's sent to me by this lab. So this lab has sent me, this fellow is Mr. Edward Engel, and he's sent me information about Susan Jones, some pictures and a full STL image. So that information now is available to me within this box here, and I can view that information as the dentist. This is the information that the person sent. So you would see that that's exactly like you would expect on any sort of email. What gets very interesting in the dental environment is that not only can I send regular images, but I can also send 3D images that are fully available within that email, within our email system. So I can view, I can rotate, I can see all of the details of the occlusion and so on, and that's all available in a fairly standard way on our system. So I'm just going to go back, look at my messages, and I've got another one here from a surgeon. But rather than go through that, what I'm going to do now is I'll just show you how we would create a message. So I'm going to create one to Wilhelm, and I just type in a couple of letters. This is a visual image of that person. I can say Stephen Jones Fix. And now I want to upload some files. And what I can do is, all I have to do on our system is find where those images are and drag and drop them into the screen. So here's the images here. I can write a quick note. I can write a quick note and send the message. And, you know, demonstrating email is sort of funny, you know, because we use email so often. At the same time, I wanted to show you that it's as simple to use as your systems are currently. So what I'm going to do now, that's really the end of the demonstration. I just want to go in and show, go back to the presentation here and finish with just a few slides. And then I think what we're going to do is get back into the questions that have arisen during the
we
presentation.
have a bunch, so there's
okay.
no shortage.
Okay, let me speed up here. All right, so a couple of interesting things about the system is that we work with your current email address. So no one should feel as though they're going to have to give up their existing email address or start telling everyone to use a different one. In fact, what happens is our system, the secure mail system, which our company is called Bright Squid, as you've probably gathered, what we do is we send an email to your regular systems. We send it to your mobile, we send it to wherever you need to, and what you see is a link to that secure message, and that's what makes sure that it's all encrypted, it's all kept secure, it's all backed up and archived and so on. So whether you're using your mobile device, whether you're using Outlook, you can click on that link, get that information, respond to the information, and exit. We've got a number of people now using our system. We've got over 1,500 users in 9 countries, 50,000 patients on our system, about 800 files per week going back and forth, and lots of surgeons, labs, and dentists using it around the world, something that we're very, very proud of and happy to continue to be a part of. There's been quite a bit written about us of late. In fact, in the June edition of Dental Town, you'll see a couple of page spread. There's Dr. Bicuspid, Dentistry IQ, and even some podcasts and other things that you can find if you look. If you just go to brightsquid.com, you'll see a lot of information there about us. So what I wanted to do just before we wrap up, I wanted to tell everybody that, again, that the pricing here is quite reasonable. We've tried to keep it as reasonable as possible. Typically, if you go to our website now, you would see that it's on for $39.99 per month, and that will set up your entire office, so all of your users. But because you've attended this webinar and given us some time to talk to you, if you enter the code Lavine, up until August 15th, we'll reduce the cost of that to $29.99 per month. So it's $120 savings a year, and hopefully that will be an incentive for you to log in and get compliant. It's a few steps to get onto a secure mail, so you can go to securemail.com. You hit the sign up button, pick the monthly subscription, which will look like $39.99, and then you enter in the coupon code Lavine. And ultimately, when you do that, you'll see that the rate goes down to $29.99 per month, and you can start using the service right away. Thanks very much, Dr. Lavine. I see that we've done pretty well with our time, but we're at the top of the hour, and I'd love to handle some questions.
Thanks, Rohit, and I think that's a very generous offer, and I would certainly encourage people to consider that. We have a number of our clients using secure mail. We're a big fan, and obviously with the HIPAA rules and regulations, it's, do you want to pay a little bit now or pay a lot later when you get dinged? So, okay, so here's a couple of questions. So you show the pricing here, and you show how to send out an email. What if the recipient isn't using secure mail or doesn't want to pay the monthly amount? Do they have to sign up all their referring offices in order to use the system?
Oh, that's a great question. So with your subscription, you can essentially give away to everyone who wants to talk to you. You can give away a subscription for them for free. Now, what happens is they get to talk to you, but they can't use their free subscription to communicate with everyone that they want to communicate with. So essentially, it gives them, as between your office or your practice and them, it gives that secure connection. And no, they wouldn't have to buy their own subscription in order to do that. Now, in the long run, we hope they do, and we hope they use it not just with you, but with everyone that they're communicating with. But that's, not for that. That's just a hope. For sure, once people on the call would buy a subscription, they would be able to communicate with everyone by just giving them subscriptions to use it.
Now, is there a limit? Like, let's say someone's got 15, 20 offices they refer to. Can they sign them all up?
Yeah, they can. That we do have some limits on the basis of our experience, and what we have found is that for that the typical office, exactly as you said, will have 10 to 20 between the lab and some of the referring dentists. So we limit it to 25. those free subscriptions that they can give away, but we haven't really come up with anyone who's gone over that. Certain specialists and labs tend to go over that number, but then we've got special pricing that we offer them for that type of service. But for the typical practice, yeah, exactly right. It's on our website. They can contact us. We'll be happy to give them a detail. They've also got more features for the lab and got more features for the specialist's office as well that are unique to the specialist's office.
Okay, and you said they don't have to change their email address. They can just use the one they've been using for years, correct?
Yeah, exactly. What we do is we notify them in their current email. So what would happen is they would use our system to move the message back and forth and get notified in their normal one. So they don't have to, tell everybody a new email address or any of that.
Okay. Now, is there a limit to the number of email addresses that you can have for each office? Let's say it's a large practice that has, 10, 20 users. Any limits on that?
We've limited it again based on our experience. We haven't found anyone to go over 10 users. But again, if there's something specific, we'd be happy to take that up on a per case basis. I think the most important thing for us is that we get the office signed up and get using the product for everybody's benefit.
Okay. Just a lot of questions coming here. What about it's interesting. You showed having the picture of the dentist. I mean, how are they going to get those pictures in there? Do they have to take pictures of all the referring dentists, or find it online, or do you have to find some file?
No, in fact, we leave that up to the person you're connecting with. So let's say let's say you and I are trying to communicate, Dr. Lavine. I send you a request so that you and I can be in connection. You would upload your own photo, and that would essentially get transferred to me once I wanted to send you a message. So if you decide to change your photo, it would change within our system, and you would be responsible for your own photo.
Okay. Now here's an interesting question, because it's obviously designed for doctor-to-doctor communication or doctor-to-lab. What about doctor-to-patient? Are some people using these to communicate with their patients?
They are. I would say that that's probably something that you're going to see us. You're kind of making me tell you a little bit of our product roadmap, Dr. Lavine. You're going to see that coming up in future releases. We're seeing very interesting type of communication between doctor and doctor, doctor and lab, and in fact, doctor and their accountant, doctor and their lawyer. We're starting to see that happen as well. So really for the professional communication, we're seeing quite a bit of that. From a patient communication standpoint, I'm going to keep it a bit under wraps because that's going to be a future webinar that we're pretty excited about.
Okay. Now this is, we're obviously everyone on here is dental, but I assume this could be used by physicians or chiropractors or any healthcare providers at all.
Yeah, exactly. In fact, not to give away too much of our business plan, but we're very focused on dental. We think we've got some very interesting systems, particularly for dentists, like the STL viewing, the DICOM image viewing, all of those sort of elements. But absolutely, you've sort of read our mind in terms of communicating with chiropractors, optometrists, legal offices even, and accounting offices and so on. Because we recognize that patient privacy is important, and so is client privilege and a number of different elements, but chiropractors are definitely on the list.
Okay. What if somebody's really interested in this, but they're a little worried about making a year-long commitment? Is there a money-back guarantee? Is there a trial? How do you typically work with an office that's interested but a little hesitant?
Yeah, absolutely. We do have free trials that are available. If people want to come to our site and give it a try. Unfortunately, when we do that, there is those screens that encourage you to buy. And so we're pretty unapologetic about that because we want to try to encourage you to buy the full-fledged system. And there are some restrictions, as you'd expect, on the free version. But people can try it. They can have a look at it. If someone's very interested and wants to give our full system a trial, we'll give them 30 days, and people can have a look and feel of the full system, and so they can give it a real whirl. So there's the free system. There's also a trial system, and if they want more information around that, please contact us. We've got a great support and service team that will be able to connect you up and talk you through the different options.
Okay. We got a lot of questions about the secure mail, so this is great. If someone has Gmail that has a ceiling storage capacity, would it no longer be applicable if you're using secure mail since it's being used as the medium? So, if you're sending like a 500 meg file, that's not really being stored in Gmail anymore at that point, correct?
Yeah, that's exactly correct. Yeah, so we have unlimited storage for people's files, and it's a bold move for us to do that, but we see it as being critical in terms of how we've built our business models. We don't want to have that cap. With 500 megabytes per message, our expectation is that we're starting to see cone beam CT scans going through our system, and we're seeing some every day go through our system. And you can't really have a storage cap if people are sending that type of information. It wouldn't, because it's not using Gmail, it wouldn't apply against that Gmail storage limit. The only thing that would happen in Gmail is that little notice that says, hey, you've just received a new message on secure mail. Click that link. And once you've clicked that link, it's back into our system.
So how does it work? So let's say an office signs up for the service and they get their specialist on board. They sign them up with one of the free accounts. You send them something, they can respond. I would assume everything that they reply to from you, it will be encrypted and going through secure mail. What if they just wanted to send a secure mail to someone else? Now, I would assume that in order to actually originate an email that they have to be a subscriber, correct?
Yeah, but we've even tried to make that a little bit easier, Dr. Lavine. So what can happen, for example, is if I'm sending something to someone who's not a subscriber or not one of my free accounts, but someone that I'd like to invite into my free accounts, all I have to do is enter their email address. Our system will automatically search if they're a part of our system or not. Assuming they're not, I can still compose my message. I can still attach what I need to attach. And when the recipient receives it, they'll get that notice in their normal email that says that Dr. Lavine has just invited you to this secure message. Click here, which will verify their name and their email address and ask them for a password. And that automatically verifies them for communications on our system. So it's meant to be super easy. It takes about a minute. We don't go through long questionnaires or anything like that. And now they have access to communicating back and forth with you.
Okay. This got so many questions coming in here. So there's no limit on how many emails they can send each month, correct?
No limit on email, no limit on storage amount. The only limit that we've imposed is 500 megabytes per message. And we've done that for very specific reasons, so that people don't send movies back and forth, I think, is how we looked at it. But 500 megabytes, as you know, you can get a lot of information. That's probably 50 high-res images or more, right?
Yeah.
And so there's lots of opportunity, but no limit on messages. We think, it was a big discussion, to be honest, in terms of how we're going to price and work with our product, and our feeling has always been that if we start to charge per message or charge per gigabyte or do any of that, we're going to discourage the use of the system that we want everyone to use. So let's just figure out what it's going to cost us on a monthly basis to run the system we want to run.
Okay. What about integration with some of the patient reminder systems like DemandForce? Because those ones typically send out emails. Are you guys looking into integration with them?
There is certainly some discussions, more on the practice management side. So not specifically with DemandForce, but I like that idea because I know that they send, thousands or millions of messages probably every day, and so that's a good one for me to look at. Right now, our discussion is primarily with the practice management systems, the EagleSofts and Dentrixes of the world.
Okay. Let's say a new patient contacts you by unsecure email and you just go ahead and respond to that email without using secure mail. Would you consider that to be a violation?
It depends on the type of information that's going to be conveyed. I think if a patient has asked you for some very specific patient information, I wouldn't risk that through normal mail. On the other hand, if a patient is asking you for some generic information like the office hours or your location, then of course you would want to be able to send that type of information back and forth over unsecure mail. But the duty really lies with the practice. The patient is trusting that the practice is doing what it needs to do to keep the information private, and so that's where I think the duty is clearest.
Okay. What if so if someone is receiving an encrypted email, it doesn't really make a difference what system they use for viewing emails, correct? I mean, they're just going to get a link. So whether they're using Outlook or Gmail or whatever, they don't have to have any special decryption software or anything like that on their computers, correct?
Absolutely correct. Yeah, there's no sort of encode decode key that's required. There's no sort of complications that people have seen through other encrypting systems that we've come across. As long as they've got username and access, they would be able to access that information. And if they don't, then they can fill in the form that they need when they come to our system, and that will give them access.
Okay. Someone asked, and I think I can answer this one, about the HIPAA High-Tech Act does not go into effect until September 2013. My understanding is that it actually has been in effect for quite some time, that there was a new omnibus rule, which is kind of a final regulations on some of the stuff that hadn't been finalized, which happened in March, and then they have until September to implement those. But I would imagine there's still, and tell me if I'm wrong, there's still a number of HIPAA and high-tech regulations that have been in effect since day one.
Yeah, absolutely. What we saw, what's going to happen, the HIPAA regulations were started to come into effect in the mid-90s. So it's hard to recognize how long that has been part of the lives of particularly the medical community. There was that modification, the omnibus rule, which goes into effect in September, which actually tightens a lot of the electronic elements that we've been talking about today.
What about, we've been talking mostly about electronic PHI. What about paper charts? I mean, are they subject to some of these rules and regulations as well?
Yeah, absolutely. And I think there was, we had one slide on that, just in terms of the data access. And so, there are things that have changed in our practices and how HIPAA has started to change what happens in a dentist's office. Now, part of that is, how accessible are the charts? How accessible are the faxes that are sitting, that have patient information? So I think the opportunity here for the dentist is to make sure that none of that information should be accessible to the public, for sure. But it's even questionable as to how many people in the office need access to that information. Now, having said that, I think the very practical rule is to make sure that the public doesn't have access to those files, that there's no specific marker on those files that would denote one patient group from another patient group. I've seen some practices go so far as to, make sure that the patient names aren't viewable on the patient chart, aren't viewable by passersby, right? You want to make sure that all of that stuff is quite protected from the public or other patients in the practice.
Yeah. We just got so much stuff here. What if someone has an email provider but they want to know if their provider is compliant? Do you have like a checklist that they can get?
Absolutely, and so one of the things that people can do in their list is in their place or in the chat location here, they can enter in the word series, which will send you, it'll send you a whole packet of information. It'll send you our previous webinar information. It'll send you our checklist. If it's really just a checklist that you're interested in, which have some of that information in it, just write in checklist, and we will send that information to you. But yeah, we've got some very specific questions that should be asked of an email provider or even a cloud provider. We've kind of gone and done a lot of work to try to simplify the challenge for the practice.
Okay, here's a good question. What if an office does not want to use secure mail, but they'd rather do is have the patient sign a waiver that says they agree to non-encrypted communication, Is that going to make the office, is that a get-out-of-jail-free card?
No. And this is a question that I think has come up pretty much in every single time we've done these webinars, and it's a point of concern. Patients cannot consent to a dentist doing an illegal act, if you know what I mean. And I've put that in a very specific way. The dentist has an obligation and a duty, and that obligation is to protect that patient's information. The patient can't say, "Hey, listen, dentist, paste it on the billboard, it's fine by me," or throw my files out onto the street because I don't care. The dentist has that obligation not to do that act. And in the same way, the patient can't consent to using unencrypted methods to communicate that information or store that information. If the patient wants to do what the patient's information is fine, but the dentist doesn't break himself or herself of that obligation, that oath that they've taken with the practice or with the profession, the HIPAA regulations do not have a get out of jail if your patient says it's okay card.
Okay. What about, and I know you obviously have an opinion on this, but what if someone doesn't want to use an email system, but are there some web-based portals that are also HIPAA compliant for sharing information?
Yes, there's one called Bright Squid.
I just read as they come in, so I'm not trying to prop you up here.
I appreciate that. But yeah, I recognize where that question's coming from. We can't vouch for anyone else's HIPAA compliance or non-compliance. There certainly are other portals. If you do some searching, I'm sure you'll find some. Our portal is one of those, and there's lots of videos about how dentists and labs and specialists are using our systems, and some testimonials about how that works. We even have, and then again, if you want to write checklist into the comments, we'll send you one so that you know what questions to ask the company you might want to use. Because not all cloud-based companies are created equal. And without being disparaging, that's all I'll say. We've got a checklist for you to ask your cloud provider.
Good. And people can get that as well.
Absolutely. Yeah, just write checklist in the comments part here, the message.
Okay. Here's one that's up my alley. What about using Wi-Fi? Can this be intercepted by others? And the answer is, I'll take the stab at this one if you don't mind.
Absolutely. Yeah. No, please do.
Yes, it definitely can. So there are a few things that we recommend for an office that's using Wi-Fi. Typically, many of the practices that we work with want to set up patient access so that they can check their email and do whatever. One of the things I would obviously recommend is that you do that as what we call a separate subnet. Many of the wireless routers out there have what's called a guest zone, where you can't see what's on the guest zone and the guest zone can't see what's on your network. If you are going to allow patients access to Wi-Fi, it really should be on a separate network so that there's no way they can get onto your network. Secondarily, you should absolutely be encrypted. It does tend to slow it down a little bit, but again, you're not normally pumping huge files over Wi-Fi. It's called WPA encryption. That's built into any decent router nowadays. And there's other things you can do to limit access. There's what's called MAC address filtering, where you could decide, I only want these specific computers to access my Wi-Fi. No one else can access it. If they try to log in, they won't be able to get in. So a username, a password, encryption. You can even turn off broadcasting so that people walking by don't even know that there's a network there. So I would certainly recommend that you take appropriate precautions if you're using Wi-Fi in your office network. What about if someone steals a laptop and gets past the password? Now they still would not be able to access the data if it's encrypted, correct? I mean, that's the whole idea of encryption.
Exactly. Yeah. No. If it's encrypted, they would not be able to get access to that information, even if they were to get by the password. That's exactly correct.
Okay. What about, like we talked briefly about these appointment reminder systems, Smile Reminder, Demand Force, ones like that. Are they HIPAA compliant in your experience?
Yeah, some of those, the ones that we've spoken with. You know, the HIPAA compliance is an interesting one because it really just deals with the practice and the businesses that are connected to that practice. It doesn't really address so much around how the patient communication can occur. And so we think that there's obviously confidentiality and privacy and other issues, but HIPAA doesn't really weigh in that much because a patient isn't a business associate. It's just a patient. And so the communication between a dentist and a patient, their schedule, what treatment is happening with that patient, there are best practices which we would say are very important to adhere to, like making sure that you've got the right patient name, you've got consent to make sure that you're sending it to that patient on an email address that they themselves have written in and made sure that it's not a family email address, for example. So there's lots of best practices with how to communicate with your patients, and I would still recommend those, but the HIPAA laws are almost silent on some of the patient communications. And so I suspect, Dr. Lavine, that these large systems like Smile Reminder and Demand Force are compliant with the extent that they need to be. So they probably have agreements with the practice to make sure that any patient data that they are taking from the practice is going to be encrypted. It's going to make sure that it adheres to all of the all of the HIPAA requirements and PIPEDA requirements. But with respect to that communication directly to the patient, it's probably outside of the HIPAA regulations.
Okay. Where does the responsibility of the dentist end if there's multiple parties involved? For example, you send information to your lab, they interact with, say, a milling center for a CAD CAM. You know, does the responsibility end once you've communicated securely with the lab, or as a business associate, are you responsible if they decide to communicate with that milling center with a non-encrypted method?
No, that's a great question, because I'm sure that happens. So let's start with the duty that doctor-patient confidentiality sort of adheres to. So for certain, the dentist is the one with the consent and with the obligation. Now they have an obligation to make sure that the images and that information is tracked. And so at any step along there, they know, the dentist should know, where that information is being used and how it's being sent. So in the event that a patient comes back to that dentist and says, you know, I saw one of my pictures on Facebook, and I know that I didn't put it up there, and it was a picture that was taken in this dental office. Now, in actual fact, what might have happened is it got sent and it got included with some secure mail, and that went to the lab, and the lab used it, and for some reason or another, they communicated with a non-encrypted method, and that ended up in a non-secure place. When that dentist comes back to our system, that secure mail, they would contact us and say, we need a log of everybody who's accessed that information and when they interacted with it. We print that log out and we'll provide it to that dentist so the dentist can provide it to the patient. While that doesn't, it doesn't really absolve anyone of any responsibility, what that does then is say, we, from the dentist perspective, the dentist and the practice and the lab all communicated securely. The chain of custody for that image, if you will, that chain of custody must have lapsed when that lab downloaded that photo. And we've got a full log of that can be audited. So the regulators can go directly to that lab and say, here was the problem, or this act was the offending act, and the dentist was in the clear with how they dealt with that information. The problem with email is that you lose track, right? You forwarded the email, but how do you keep track of where it's been forwarded after that? It's impossible, right? Whereas we can give a full log of what's happened with those images.
Here's a question I think you and I can both address a little bit is, what about using remote access? And, we are a little bit guilty of this because we've been installing remote access for our clients forever. 85% of the offices that I work with are not in California, which is where I'm located. And it has come up with a few of our clients, what about HIPAA? And you had actually showed a slide on this, Rohit, that talked a little bit about it. And where a lot of the remote access programs, in my mind, fall short is two areas. Number one is auditing. That there has to be something in place that if someone ever came to us and said, you guys were logged into my computer, or we know that someone was logged in remotely, do you have a log of that? Can you let us know who it was that was logged in and how long they were on there for? The other area where we find a lot of the inexpensive, and again, we've been guilty of this and we're changing the way we do business, but the other area is that it has to be able to log you out automatically after a certain period of time. A lot of times, you might log into your computer from the office at home and just leave it up like that, which obviously is not HIPAA compliant. Is that your take on it as well?
Yeah, no, there's some of these programs, and I'm not familiar with which ones, but they will have an encrypted connection, which is excellent. They'll have, so that security will be there. It's the auditing and the automatic log off those are the ones that we see are lacking in a lot of systems. And I couldn't agree more. It's a bit of a hole here because everyone wants that convenience, but you want to make sure the tools that you're using are HIPAA compliant.
Yeah, I would agree. What about if someone is using email, but it's an in-office network? Maybe they have their own Exchange server, for example, inside the office, and the dentist communicates with a staff member. Would they still have to use a secure system?
That's a great question. So as long as that system was encrypted and all the connections were secure, that would be okay. The challenge comes is as soon as you're trying to send that information outside of your own network. So even if it's okay inside that network, as soon as you send it to someone's Gmail address or as soon as you send it to a lab, even if they have their own email server, so even if it's Exchange to Exchange, that's going over unencrypted transmissions, and that's where the problem occurs.
Okay. What about, someone's asking, they're a little confused about the difference between, I guess you're talking about the 25 sponsor limit and the free email recipients. Can you just go over that?
Yeah, so when someone purchases a system, our system, a secure mail account, let's call it, they can add up to 25 business colleagues that they want to communicate with. Every one of those 25 colleagues will get a full system as long as they're communicating with the person that paid for their account. So my practice, I could invite 25 people. Each of them would get a full account as long as they were communicating with me. If they turned around and wanted to communicate with 25 more people, we would give them a subset of functionality, and that's where that free element comes in. So they wouldn't have the same sort of functionality. They don't have archiving, but they can test the system. And so that's sort of where the differentiator occurs. The 25 accounts get a full get full access and full use and full archiving with any communications, as long as they're communicating with that sponsored account, or as long as they're communicating with the person who paid for that account.
Okay. Now, someone's saying, because you had mentioned that the system at this point isn't really geared towards doctor-patient services. Certainly, the Bright Squid, the dental link, in my opinion, would be a good option for that. Are there other ones out there?
As far as doctor-patient, we haven't come across great systems. I mean, most people that we've come across rely on their sort of Gmail servers and otherwise, which is one of the reasons that we're looking at building it into our system, is because we think there's a huge opportunity here to really embed ourselves and to facilitate what the dentist wants. And a lot of that is communicating securely with that patient.
Okay. We're starting to run out of time and run out of questions.
Yeah. Well, as we've done before, we look forward to answering the questions. And I think depending on the webinar, our team has the tomorrow booked off. I can tell you that, to try to get all these questions answered and get everything back to anyone that's on the webinar. So we'll make sure that we do answer them and that we get all that information to everybody.
Now, if someone has more than 25, I mean, I assume that you would allow them to do that, but it would be a small cost associated with that.
Yes, small cost, yeah.
Okay. If someone's using the secure mail, can they customize the origin of the email addresses with their business? But I guess it's just going to be whatever your email address is, correct?
Yeah, you use so your normal email still gets used, but any message that you do send out, like the first message, for example, where you're inviting them into the system, all of that stuff we grab the photo, we grab any logo that you might have uploaded to our system, and we make that a branded experience so that your colleagues recognize the email coming from you. But once they've connected to you, then it's kind of just like using normal email. You know, one of the things we are looking at is putting a signature line so that people continue to include their brand in that. But that's in an upcoming release.
Okay. Well, we are running out of time, and I've got a 6-year-old who would like to enjoy having late dinner with Daddy. So we got to most of the questions. I would certainly encourage people that when you log out, just indicate, would you like me to follow up with you? Would you like Rohit to follow up with you? He's going to get a list of everyone, what questions they ask. So you can indicate on there, yeah, I'd like to know more about secure mail. As I had mentioned, we have a number of our clients using this system. They rave about it. It's so easy to set up. And that was the problem with some of these older systems, is that, you know, the recipients all had to have these decryption keys, and, you know, they had to have the same software, and it was just a pain. And one of the things I really like about the secure mail is it's eliminated that human element that, yeah, you know, you get an email from somebody, you sign in with a username and a password, and at that point you're now part of the system, and you can send and receive secure mails. Rohit, I just want to thank you so much for being on this. I love doing these webinars with you. We get great feedback. I know with the omnibus rules that are coming into effect this September, I think our timing is good because I believe we are scheduling another webinar for sometime in September. So it would be great to, you know, focus on some of the things that people really have to start. You know, it's becoming less optional, and, you know, by the end of September, it's like, you know, now you are 100% in violation. So thank you so much for being here.
My pleasure, and thanks for everybody's attention. Dr. Lavine, a pleasure as always, and look forward. I love the idea of doing something in September, sort of marking the omnibus rule and where people should be by then. So look for us sooner, I suppose.
Great. Well,
right.
As I said, there were a few questions that we could not get to, but I will forward those questions on to Rohit, especially relating to the secure mail system individually. I know he'd be more than happy to give you a chance to try it out and make sure you like it. And as I said, we've got a lot of our clients using it who have not a negative thing to say about it. So it's definitely a great, I think a great service. So thanks, Rohit. We look forward to
my pleasure.
In future webinars. Many of you know that I do these webinars on a regular basis. I can't remember what we got coming up next week, but we have more, so stay tuned. Most of you are on my list, and we'll be sending invitations. We know how valuable your time is and want to thank you. Take advantage of this special if you're thinking about the secure mail. $30 a month. I mean, it's nothing. Most of you spend that much in a week on coffee. So I think it's to meet the HIPAA regulations. And the flip side is if you ever get audited and found that you're not in compliance as a first-time offender, you're probably looking at somewhere between $25,000 and $50,000 in fines. So it's pay a little bit now or a lot later. So thank you all again for joining us tonight, and we look forward to seeing you on future webinars. Good night, everyone.
Good night, everyone.